Hello everyone, we were discussing the fundamental rights, and in that we had seen the first fundamental right or first category of fundamental right, which extends from Article 14 to Article 18, and that is called right to equality. And today we are going to discuss the right to freedom, which extends from Article number 19, then it goes to 20, 21, 21A, and then we have 22. So from 19 to 22 we have fundamental rights of freedom. So before we start, let us analyze this particular statement by the Supreme Court or by Justice D.Y. Chandrachud. He says, dissent is the safety valve of democracy. If you don't allow dissent, then the pressure valve of democracy will burst. What does it basically means is that dissent and democracy, they go together. In a democracy, you have this permission to show your dissent, which is not there in monarchy, which is not there in autocracy. The example can be cited as France. So before the French Revolution, dissent voice was not allowed, and the king and the church, they used to rule over the people. So what eventually happened? There was a revolution where many people were killed. So if you don't want that to be repeated, a revolution to take place, then you will have to provide space for deliberations. Okay, whatever the concerns of the citizens are, they are genuine concerns, they should be discussed. If you will avoid discussing over genuine concerns of citizens, that may lead to revolution, as happened in the case of France. The revolution only took place when the life of the common masses became unbearable. So that should not happen. Whenever the citizenry thinks that their life has become unbearable, they will protest and show that through dissent. So dissent should be allowed. Dissent is the safety valve of democracy. If you don't allow dissent in those societies where dissent is not allowed, revolution do happen. Then the pressure valve of democracy will burst, and that bursting is nothing but changing the regime. The democratic regime will change, and there might be revolution, bloodbath, etc. So to avoid that, a democracy should always have space for debate, discussion and deliberation and dissent. So you can write these 3 or 4 words together. They all start with D, or you can add 5th one, democracy. So democracy means dissent, deliberation, discussion and debate. If you will write in your essays, or if you will speak like this, that democracy means dissent, deliberation, discussion and debate, you are going to get good marks. Okay, now we are going to discuss fundamental right to freedom. So that dissent can be shown through fundamental rights of freedom. They are given in Article 19, Article 20, Article 21, 21E and 22. So Article 19 says about free speech. Article 20 says people who are convicted, they have certain fundamental rights. Article 21 says every person has right to life and personal liberty. Article 21A is nothing but right to education. And Article 22 says when you are acquitted or going to be convicted, then what should be the procedure which should be followed. You have certain fundamental rights there also. So Article 19 is very important. It has 6 sub-rights which are important. So it says protection of certain rights regarding freedom of speech, etc. All citizens of India shall have the right. 6 rights. What are they? Number 1, to freedom of speech and expression. You have the fundamental right to speech and expression. You can express your views. You can write whatever you think. B says to assemble peacefully and without arm. Peacefully and without arm. If you are protesting or doing something, that is allowed in our country. That is not allowed in countries like China. That is not allowed in monarchy maybe. But in a democracy, as the people are supreme, they are allowed to put forward their concerns, because it is the government of the people. To form associations or union. So different group of people can come together and form associations or union. This particular article is also important for those of you who are applying for HRM courses, because the trade unions are formed under this particular provision. Then the next says to move freely throughout the territory of India. Now what does it mean? Anybody any Indian is allowed to move freely in any part of the Indian territory. No one can stop you. There are certain areas like scheduled areas, which are tribal areas where one requires permission, but apart from those areas and some protected areas like national park, apart from those areas, you can go each and everywhere to move freely throughout the territory of India. And here one thing is important. During the British era, there was a signboard which was quite common that dogs and Indians are not allowed. You can't have such signboards right now that dogs and Indians are not allowed. And then to reside and settle in any part of the territory of India. So you can settle in any part of the Indian territory. A person from Northeast can settle in Delhi. A person from Bihar can settle in Maharashtra, Gujarat if he wishes. Okay, similarly, a person from Maharashtra can settle in Delhi. He can settle in Bangalore or anywhere he wants to settle, because our constitution do not restricts a person to reside at a particular place. Then to practice any profession or to carry on any occupation, trade or business. So they are allowed to practice any profession. There are some professions which are not allowed, but that we'll discuss later. But most of the people are free to practice any profession, to carry out any occupation or business. But there are some reasonable restrictions. Nothing shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the rights conferred by the said clause. On the ground, number 1, in the interest of sovereignty and integrity of India. Number 2, the security of the state. Number 3, the friendly relation with a foreign state. Number 4, public order, decency or morality, or in relation to contempt of court. So you can't go on saying anything which disturbs the public order or which is immoral or is not decent. So sometimes that is not allowed. And then again, contempt of court is not allowed. You might be aware of Kunal Kamra and Prashant Bhushan. So you can't say something which is against Supreme Court order, number 1, or which is disparaging to the Supreme Court. Now defamation or incitement to an offense is also not allowed. You can't give speeches which talks about rights, etc. Okay, you can't encourage people for rights. If you will do, then you can be punished. Then defamation, you just can't say that without any evidence or proof that this person is bad or bad. In India, freedom of press is implied from the freedom of speech and expression guaranteed under Article 19(1)(a) of the Constitution of India. So if a question comes, freedom of press is emanated from which particular article, the answer will be Article 19. Then RTI, or right to information, is a fundamental right and is aspect of Article 19(1)(a) of the Constitution. This is also important. And these two ladies you are seeing, they are RTI activists. The first one is Arna Roy, the older one, and the younger one is Anjali Bhardwaj. These two names are also important. Now come to Article 20 basically. So Article 20 talks about 3 things: no post facto law, no double jeopardy, and no self-incrimination. Suppose a person committed a crime, and when he committed the crime, the punishment for that was 5 years of imprisonment, and now he has been caught, and now the punishment for the same crime is 7 years of imprisonment. So whether he will be given 5-year or 7-year terms, so that will depend upon the time when he committed the crime. He committed the crime during that period when the law was that he should be punished for 5 years. So he will be punished for that particular period. As it reads, no person shall be convicted of any offence except for the violation of the law in force at the time of the commission of the act charged as an offence. Then it talks about no double jeopardy. What is it? No person shall be prosecuted and punished for the same offence twice. Now it cannot happen that you committed the same crime and you are being prosecuted in different courts for the same crime again and again. No, only one court once can punish you. No self-incrimination. This is third one. No person accused of any offence shall be compelled to be a witness against himself. Okay, they can't force you to give evidences against yourself. And from here, and also from article 19, so in class I said that only from this article the right to silence comes, but no, right to silence comes from both the articles, article 19 and article 20. So this is very important. In 2010, the Supreme Court found that forced narco-analysis, brain mapping and lie detector tests violate article 20 part 3. Okay, so here we will have to understand a person has right to silence, which emanates from article 20 and also from article 19. Then article 21, it is the heart of fundamental right as observed by the Supreme Court. It says about protection of life and personal liberty. No person shall be deprived of life or personal liberty except according to the procedure established by law. Now, if a person does something which is against the procedure established by law, suppose he kills someone, then that person will be deprived of his life because he might be sentenced to death. In that case, it can happen. But apart from that, nobody can be deprived of his life or personal liberty. Only that is allowed in case a person is against procedure established by law. Now, under right to life and personal liberty, there are certain cases which are important. The first one is Putta Swami judgment, which came in 2017. It talks about right to privacy, or it says right to privacy is a fundamental right. So a direct question can be, right to privacy is a fundamental right under which of the following article? The answer will be article 21. Then Hadia judgment, right to marry person of one's choice. That is also part of article 21. Okay, this is also important. It came in 2018, I think. Then right to die with dignity. The Supreme Court held that the right to die with dignity is an intrinsic facet of the right to life under article 21 of the Constitution of India. It allowed for passive euthanasia and living will. Now, what is passive euthanasia? When you stop the medication for some person and he eventually dies, that is passive euthanasia. And what is active euthanasia? When you insert a poison inside a person and he dies, that is example of active euthanasia. So it is euthanasia is merciful killing of some person. You can kill a person through inserting some injections, or you can stop the medication. That is also a way of killing him. And before killing, there should be some living will, where the person has given you the permission that whenever I go into a vegetative state, you can kill me. Without living will, you can't perform euthanasia. This is also important. And this particular judgment came in the case of Aruna Ramchandra Sambhav. Okay, this name is very important because a question might come that this particular name is related to which of the following cases. So you will have to remember in mind that it is related to passive euthanasia or living will. And the right to die with dignity is a fundamental right in Article 21. So during this second wave of COVID, again there was issue that many people, they didn't have their last right. So having a proper last right also comes under right to die with dignity. Okay. Now come to Article 21A. It talks about right to freedom of education. The Constitution 86th Amendment Act 2002 inserted Article 21A in the Constitution of India to provide free and compulsory education of all children in the age group of 6 to 14. This age group is important as a fundamental right in such a manner as the state may by law determine. And there have been several schemes like Sarv Shiksha Abhiyan, Beti Bachao, Beti Padhao, etc. Now come to Article 22. It talks about protection against arrest. The Article 20 was with respect to a person who has been convicted, and this article is with respect to a person who is getting arrested or detained in certain cases. Protection against arrest and detention. Number 1. No person who is arrested shall be detained in custody without being informed of the ground of such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Number 1. a person who is arrested, he should be shown some notice why he is arrested. Number 2, he should be allowed to take legal advice. Then every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours. And that period of 24 hours cannot get extended without a permission by the magistrate. No such person shall be detained in custody beyond the said period without the authority of a magistrate. So these are the 3 rights you can say. Number 1, he should be told the ground. Number 2, he should be allowed to keep a legal advisor. Number 3, every person should be produced before a magistrate within 24 hours. Then number 4, that period cannot be extended without a permission of magistrate. Now Article 22 also has preventive detention that we will discuss in our next video. So this was all for today. Thank you. Thanks for watching.